My name is Drinovz. I'm the head of the Employment and Labour Group at Kane, Shannon, Weiler. KSW is a full-service firm, and our Employment and Labour Group works extensively with the other practice groups in the firm. And the idea is that we're full service, but we have a number of different groups with expertise in particular areas. If the employment matter ends and our client is looking to do something else, I can refer them on to someone else in the firm and maintain that continuity of the relationship. Employers are seeing a lot of accommodation requests from employees. That might be remote working arrangements, working part-time from home, working staggered hours so they have time off to take care of kids that have stayed home or take care of relatives. Employers need to be aware of their obligation under the Human Rights Code to accommodate. This might include accommodating a family status. This might include accommodating a disability. Whenever you are faced with an accommodation request, what I recommend is that you speak to a lawyer, figure out what your obligations are, and once you've learned what those are, work with the employee to come to an accommodation that makes sense for the business and the employee. And when you've done that, make sure you get it in writing. If the duty to accommodate requires the employer to do everything up to the point of undue hardship to accommodate an employee if there's a protected ground involved. So if there's a disability or a family status obligation that needs to be accommodated, the employer basically has to do everything up to the point where it's going to be very, very difficult for the business to make the accommodation. So it's quite a broad and extensive duty. The consequences for breaching the Human Rights Code can be very significant. That could lead to significant damages. So before you get to any of those stages, it's best to sit down with the lawyer, sit down with the employee, and figure something out that's reasonable, that allows you to keep utilizing that employee to the best of their ability and your ability, but also strikes a balance between their family needs or their medical needs. So as a general principle, it's best to put down the terms and conditions in writing at the beginning. If those terms are going to change because of an accommodation request, it's best to do an amended agreement. Or if you don't have an agreement, do an accommodation agreement, which clearly outlines what the new schedule is going to be, what the new hours are going to be, if there's any flexibility, and there's no confusion or gray area when it comes to interpreting the agreement or interpreting the accommodation. Because if you do allow an accommodation to occur for a period of time without documenting it, the employee could argue, well, that's the new agreement. But that may have been just a temporary thing that you were willing to do, right? So it's always best to have clarity. Ambiguity is not good. Relying on past conduct is not good. You want to have a written agreement with the employee. Yeah, so there's lots of template agreements online. I highly recommend against that. I know I'm a little bit biased when I say that, but I have taken over a number of files where the business had drafted their own agreement, or they'd relied on a precedent they found online, or even relied on something that the employee had presented to them. And oftentimes those agreements are generic in nature. They may be from the States, they may be relying on American law, or even the law from another province, which differs from British Columbia. So it's very, very dangerous to rely on those sorts of agreements. The language matters, and when you're the employer, the court looks at the agreement and it interprets it against you, because you are the party with the greater resources and power. And so there's a legal principle that says if you're the one drafting it, the language is going to be interpreted in favor of the other party, the employee. So you need to be very careful with the agreements and make sure they're drafted by a professional. So one thing we always pride ourselves on is we provide the quality of service that the lawyers downtown provide. We battle with those lawyers in court if we have to. We stand our ground with them if we have to. But we're here in the Fraser Valley. We're local, and we don't have the same cost of living, cost of rent as the lawyers downtown. So we're able to provide the same quality of service, whether it's drafting contracts, giving you advice, or going to court, but at a lower rate. People are surprised when they see our prices and our rates. There's a lot of businesses that are set up here, but they're still using lawyers downtown. And when they see that they can use local counsel for sometimes half the price and get the same quality of service, it's definitely a surprise to them.